after Karen Reed's acquittal, there are still things that are going on. Finishing out what's going on in the criminal case, I am very interested in because Karen Reed's attorneys have made a motion to release the sidebars, release the impoundment. And I'm very excited about that because the judge recently extended the impoundment order, but her attorneys are asking to release the sidebars. We will talk about that motion in just a little bit. They are also asking for return of property in 2 different cases because remember, there was the indictment to nowhere with Karen Reed and Turtle Boy Aiden Carney that was not an indictment. No one was indicted, and she had cell phones taken from her in connection with that. But there's also the things that were property taken by law enforcement for the criminal case, most notably the Lexus and the cell phone. So we're going to talk about return of property on those things and where we go from there. And so there are still things happening in the criminal case. It's not all the way done. So let's look at the motion to return property. This is a very brief motion. Ted Daniel shared a photo of it on Twitter. Motion for return of property. It's not your eyes. It's not your internet. It is, in fact, this motion. It is so difficult to see. This was filed July 28th. Now comes Ms. Reed in the above entitled matter and respectfully moves pursuant to Superior Court Rule 61 that this honorable court order the return of all of Ms. Reed's personal property, including but not limited to the following items: 2021 Lexus LX 570, personal cell phone. As reason, therefore, counsel attempted to negotiate the return of the listed property with ADA Adam Lally in late June, as property is in the possession, custody, and control of the Massachusetts State Police and has not heard back. Thus, counsel is respectfully requesting this honorable court order the return of the items immediately. We are so far into the realm of shit that shouldn't be happening that I am still continuing to buffer because these are things that are a regular, easy, and normal part of the job that just happen or should happen in a routine way. So the question that all of you are going to ask, what about the Lexus? What about the damage to the Lexus? There's not much that can be done about the damage to the Lexus. We'll see if her attorneys try, but the way that the Lexus was taken apart was part of the investigation. And because of that, she's going to have to fight it out with her car insurance. And I don't know what car insurance in a given area chooses to do, because all of the vehicles that I dealt with that were in evidence and part of an investigation were in substantial vehicle collisions. Karen Reed's vehicle was not totaled until the investigation took it apart. So it's actually a very unique situation in that the vehicle was damaged as part of the investigation, but it was not already damaged and undrivable. So I don't know what insurance will do with that. But it's my understanding from everything that she is still paying for the car. I don't know if the car can be put back together. I don't know if you can take it back to Lexus and be like, can you put it back together again? Or if you just, I don't know, sell it for scrap. I don't know what you do. But it'll be interesting to see what happens with that. I don't know the answers. I imagine on Karen Reed's end, she probably, and this is just purely my speculation, I would imagine she doesn't want to drive it, doesn't want to own it, and doesn't want to still pay for it, and just wants to be done with it and get rid of it and just be like, done. Or fix it and sell it or whatever. But it is something that she is still paying for and needs to resolve dealing with that. And then as to the cell phones, if you are in Karen Reed's position and you get back, it sounds like 3 devices, no matter what you do to those devices, do you trust those devices? I think her lawyers probably have questions and might want to take a look. So it's going to depend on how much energy can go into this, but maybe having those investigated and then getting rid of them. I'd be really interested in that, but I wouldn't want them in my house. But she still has the right to them back. Defendant Karen Reed's motion for relief from the April 14th, 2024 order to impound sidebar conferences. Now comes defendant Karen Reed and respectfully moves this honorable court to release the transcripts of sidebar conferences that occurred prior to and during the 2 trials in this matter from the court's April 14th, 2024 order of impoundment. As grounds for this motion, Ms. Reed states there that good cause no longer exists for impoundment. Yeah, the case is done. Ms. Reed relies further on the attached affidavit of counsel, which is incorporated herein. Background. On April 10th, 2024, the Commonwealth filed its motion in limine for appointment of court stenographer, ongoing order to impound all sidebar conferences, and impoundment of juror names during trial. I have no problem with impoundment of juror names. I really don't. If jurors want to come forward and talk, they can. If they don't have to. I have no problem with impoundment of juror names. It does not bother me. The Commonwealth sought impoundment of the names of all jurors, all sidebar discussions, including sidebar discussions during pretrial proceedings, which was so dumb. It's like, this doesn't need to be at sidebar. There should be very limited things at sidebar during pretrial. There's no jury there. And the only things that should have been at sidebar during this were things about the federal investigation, because those properly should have been sealed. The Commonwealth sought impoundment of the name of all jurors, all sidebar discussions, including sidebar discussions during pretrial proceedings, and that sidebar discussions and juror names be unavailable until a verdict is returned. The Commonwealth's rationale was that, quote, the publication of matters discussed at sidebar, including juror names, information, and potentially sensitive responses to inquiry while the trial is ongoing could prejudice the parties and expose jurors to extraneous matters. Legal standard. Rule 7 of the Uniform Rules of Impoundment provides that a judge evaluating a motion to impound documents may enter an order of impoundment only if good cause to withhold the documents from the public is shown. Again, I think the jurors meet good cause. I think the rest doesn't. To determine whether good cause is shown, the judge must balance the rights of the parties based on the particular facts of each case. And then they cite case law regarding that. Once entered, an impoundment order remains an interlocutory order subject to continued existence of good cause, which means it's ongoing during the case. Unlike other orders or judgments, an impoundment order carries no continuing presumption of validity to sustain it against a proper challenge subsequently brought. A party seeking the release of impounded court records does not bear the burden of demonstrating either that there has been a material change in circumstance or that whatever good cause may once have justified their impoundment no longer exists. The burden of demonstrating the existence of good cause always remains with the party urging their continued impoundment. A proper challenge to the continued validity of an impoundment order is raised whenever the party seeking to modify the order comes forward with a non-frivolous reason to do so. Argument: because good cause no longer exists for the order of impoundment to be continued with respect to the sidebar conferences, and because access to those materials is required for trial preparation, the impoundment materials should be released at a minimum to the parties. We would also like them. Please don't just limit it to the parties. An order of impoundment related to the sidebar conferences was entered by agreement on April 14th, 2024. On November 13th, 2024, the court further ordered that certain transcripts of sidebar conferences be provided to counsel and the court. See Exhibit Docket. The court issued a separate order for impoundment of the list of jurors for the second trial on June 18th, 2025, and extended that order on June 26th. That's what we thought. The attorneys go on to say, in accordance with these orders, the identities of the deliberating jurors in both trials in this matter remain impounded. Good, leave it. That aspect, the identity of the jurors of the Commonwealth's April 10th motion, remains unchallenged here. Good. As the issue of juror identities was subsequently addressed by the court, Ms. Reed instead seeks only the release of sidebar discussions that took place during trial. Good. And those that addressed evidentiary rulings prior to trial, because the, quote, good cause the court recognized when impounding such conversations no longer exists now that a verdict has been rendered. Agree. Originally, the Commonwealth was concerned that the release of sidebar conference transcripts during the pendency of the first or presumably second trial could expose jurors to extraneous matters. If the jury is on the internet looking at this case to the depth that they are seeing coverage of sidebar conferences, they're probably not going to be jurors on the case anyway, but I get the argument, especially because some of those sidebars involved a federal proceeding and there was much unknown about whether that was proceeding, not proceeding, or the rest of it. However, the attorney goes on, now that the trial has concluded, the issue is moot. It is. It's moo. I agree. As the Commonwealth noted in its motion, after a verdict is returned, the potential prejudice to the parties will be greatly lessened, and that all parts of the record, except any that the court specifically finds subject to further impoundment for good cause, would then be made available to the public. Though Ms. Reed does not bear the burden of establishing that good cause no longer exists for the order of impoundment to remain in effect, and need not establish a material change in circumstances, it is apparent that any good cause that did exist during the trial for the order of impounding sidebar conversations is no longer present. The factors the court must consider in determining whether to continue its previous order of impoundment all suggest that the referenced sidebar conferences should now be part of the public record of these proceedings. For these reasons, Ms. Reed respectfully requests the court release any sidebar conferences that occurred during either of the two trials in this case and any pretrial sidebar conferences dealing with evidentiary issues. Oh boy. Ms. Reed also respectfully requests that the court allow this motion administratively without a hearing. Yeah, just sign it is what they're asking for. We'll see if the court does that. Karen Reed's attorneys are asking for the sidebar conferences to be released. And interestingly enough, when they titled this motion, they indicate that they need the sidebar conferences in preparation for trial because there is still a civil trial pending. And they are asking for just the legal rulings, not the juror names. So Karen Reed's attorneys want all of the impounded or sealed sidebars not relating to the jury to be released to counsel and ultimately to the public. That is going to cover the sidebars from both trials. That's a substantial amount of sidebars because they didn't just do sidebars at trial. One of the things I was so frustrated about between the first trial and the second trial is that when we were getting into the second trial, all the pretrial hearings, they went to sidebar with stuff too. And so there was a ton that was happening at sidebar that I am interested to see. And we can summarize it. We probably won't go through every single sidebar, maybe the spicy ones, because we know there were some of those. But it's going to be a substantial amount of transcripts. At some point, we will go through them if and when they are released. It's interesting to see that they are still impounded and that order doesn't automatically terminate when a verdict is reached. So the defense is still needing to make motions asking the court to remove the orders that have not yet been removed. I will be keeping an eye on the docket. I don't see a legal reason why these should remain sealed. We haven't seen opposition to this motion. The defense attorneys asked that this motion be granted without any hearing or argument on it, which makes sense because the risk of prejudice to a potential jury does not exist. I'm interested to see if anyone makes an argument that because there may be a jury in the civil matter, that perhaps there still is a jury, but that is a separate matter from this. It's not the same. And this is not being heard in that court. There is no more jury in this cause of action. And the entire two trials were public. So the shit's kind of out of the horse on that one. We will see what happens with the Karen Reed sidebars. I imagine that they will get released. I will be surprised if they don't because there is no longer good cause to keep them sealed. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the LawNerd app at lawnerd.app.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.